from Salzburg in Austria, from the IRIS 2022 conference. This is something we have done in the past. I think the last time before the pandemic, but it's wonderful to recontinue to pick up this tradition again and get sort of a mini workshop from IRIS, which is one of the best known and long running conferences in the legal informatics space. And Professor, I'll guess Professor Schweikhofer, of course, who's I think who founded the conference, and he will get us started, and then we'll hear from Sebastian Leitner from the Federal Computing Center of Austria on e-justice in Europe and Austria. Then we'll hear from Judge the Honorable Isabel Bialas, who's a judge in Germany. And then we hear from Stefan Eder, who's a lawyer in Vienna and who's also very involved in the legal tech community in Europe. And so I'm pretty excited to have you all here for our group meeting. Thank you so much for staying up late. It's already, I think it's like 10:30 or so in Austria. So it's great to see you, Erich. Over to you.
Thank you. Actually, we are mostly at home because we have still a pandemic here and we have to be careful. So there are conferences mostly online. So, and most are at home in their, I guess, in the various laptops, homes. Just a small comment, e-justice is a success story in Europe, particularly in Austria, and it's mostly driven by the public sector. You have strong groups of lawyers who are engaged in, and it's well organized as such. In Austria, it's the Ministry of Justice and the Federal Computing Center who are doing the work. In Germany, there's the EDV Gerichtstag, a very big event actually every year in Saarland. And you will get what they have in mind, what they do. And it will be then rounded up by a solicitor saying, yes, what I think about this. And we'll start with the German presentation, then the Austrian one, and then the roundup, and then there's a lot of time for questions. So we're really eager to hear, how is it good? Are you much better? We don't know, and we will find out. So I guess first speaker will be Isabel Bialas. She's a lawyer in the court of Essen, but active in the EDV Gerichtstag, the Federation Association of the German judiciary, holding a meeting every year in Saarbrücken, very well attended and very interesting meeting. So I guess, Isabel, it's yours.
Hi, I can't activate my video myself. Okay, thank you. Thanks for the very nice introduction. I'll give you a brief overview regarding the e-justice projects in Germany and Europe. Someone stop my video again. So now you should see me again, and I hope you can see my presentation too.
Yes, thank you.
Great. So after the slight different difficulties, let's get started. Thank you for the very nice introduction, and thank you for inviting me to the session. I worked for 3 years as a legal officer in the Ministry of Justice of North Rhine-Westphalia, one of the 16 federal states of Germany. And now I'm back at court and working as a judge at the district court in Essen. I will show you what we are currently doing. We are in the middle of a very big project to make our courts fit for the future. The past situation were big paper files, and the lawyers had the choice if they wanted to file something electronically or if they would file paper documents, and emails were not possible. And currently we are doing a three-pronged approach to start the e-justice in Germany. The first is the centralizing of our IT infrastructure. In the past, we had the servers in every court and every public prosecutor's office in the basement. And now we have centralized big servers where the court files for all courts and all public prosecutors' offices in North Rhine-Westphalia at the same place. The second big part is the electronic exchange of legal documents, and this is mandatory for professionals. And the third part is electronic court file. There were federal mandatory laws to make this possible, and it's a step-for-step approach for 8 years. And we are currently somewhere in the middle of it. One of the big problems were that some of the competencies were at the Bund, our federal government, and other competencies were at the Länder level, at the state level. And our Länder are sometimes not able to make the same choice. So for example, we have three different e-file systems and not one. A few short words to the centralization. We hosted it's on our own. It's part of the Higher Regional Court of Cologne. And there we established a center that hosts the service. And the reason for this approach were constitutional, to make sure we grant a separation of powers. It was not possible to use server farms from our Ministry of Interior or from external server farms. And it is a really big project because we have to be able to build servers for the 226 courts and public prosecutors' offices in North Rhine-Westphalia. And we have to be able to host the Citrix environment for 25,000 users. And we will centralize all districts and all ordinary and specialized courts. Part of the reasons for the centralizations were the increased requirements, for example, due to the general data protection or due to information security. And our goal was to create a modern and sustainable IT structure. And it was a prerequisite for the rollout of the electronic file. Now I share with you a timeline. Before the beginning of 2018, every judge needed to check which court was willing to receive electronic documents and which not. We talked about a patchwork within Germany, and this was changed. The courts and the public prosecutors' offices were all willing to receive electronic documents. And since the beginning of this year, professional parties, lawyers, and administrative bodies are obliged to send their documents to court electronically. So there we are. And at the beginning of 2026, the electronic file will be mandatory for all courts and public prosecutors' offices. So at the moment, when the lawyers send us something electronically, about half of the courts in North Rhine-Westphalia work with the electronic file and can use the document, and the other half needs to print it out and work with it in the paper file. we use the so-called EGVP, the electronic mailbox for courts and for administrative offices to exchange documents. It uses a German standard for the public administration, and it works with a principle of two encoded containers, and the usage data and the content data are in separate containers. During the transport, the legal data is secure and will not be opened. This EGVP, as we call it, can be accessed by a specialized mailbox. I have a big list with German names. These are the specialized mailbox for certain groups, for example, lawyers or notaries, or we'll have a new box for tax consultants. And since the beginning of the year, we've created a mailbox called EBO, and this can be used by all legal and natural entities. So every citizen in Germany can decide to create a mailbox to communicate with the courts electronically, but this is not mandatory. They can choose it, or they can decide not to do it. We have communication solutions, the email and user mailbox to communicate with administrative offices, and we've created an interface so people who've created this kind of communication device can also contact the courts on this way and can be served on this way electronically if they allow access. Requirement for the use of a document is only an electronic signature. For example, the lawyer who sends something to court and uses his specialized mailbox can just write his name and write lawyer. They type it at the end of the document, and that's enough. They do not need to use a qualified electronic signature or something like this. If they just use the EGVP, they can buy a software to access it, but then they need to use a qualified electronic signature according to the EU regulation EIDAS, and their hash word is built to make sure that the document is really from the person who claims he is a sender. For the rollout for the electronic file, we choose a step-by-step approach. We pilot first for the cases we want to try, and then there is a rollout for every court who uses them. We started with civil matters, but we'll also have the family courts, insolvency code, and so on. And the same with the criminal court. We started with small misdemeanors. For example, if I work on misdemeanors, I already do it at the electronic file. But if I have big cases, rapes or something like this, this I currently still do with a paper file. And in the specialized court, we have finished at the finance court. We'll finish this year at the administrative court, and it's still ongoing on the ordinary court where I work, on the labor court, and on the social court. We don't scan documents, but when we have new cases, they are started from the first electronic document ongoing as an electronic file. And so step by step, we'll have less and less paper and more electronic files. And we plan to finish a rollout in 2025. And we have the deadline 2026. And it is a really big project for us. We started in North Rhine-Westphalia in 2008. The first prototype was built in 2011. And then you see the problem underneath. We have these 3 different groups of federal states, and they all have different systems. And for example, Austria is part of the group of the system that was developed in Bavaria. So we have kind of a little connection to Austria. If people want to see the file, for example, lawyers, they have access to an access portal. The file is uploaded in PDF format, and they can download it for some time, and then it's deleted. And I will finish with some works for cross-border electronic exchange. And my colleague Sebastian will talk a little more about it. North Rhine-Westphalia was one of the countries that wanted to push forward the electronic exchange between the different member states of the European Union, and we use the E-Codex technology. And it will be mandatory quite soon, and is a really great generic reusable solution for cross-border exchange. And we already have some pilot cases. Now I am a little too far. We have some in civil law, and you see now the slides that we already have some in criminal law. For example, North Rhine-Westphalia is on the border to the Netherlands, and 5 public prosecutors' offices in the Netherlands and in Germany and 2 in the Netherlands already exchange their European investigation orders electronically and not on paper. And we have big projects to make this possible for more member states. Currently the EXEC2 project, and we already exchanged some documents in the mutual recognition of financial penalties. So this was kind of a tour de force through our e-justice projects, and I could have said much more, but I think my time is already over. Thank you very much.
Thank you. Yes, just for the framework, is North Rhine-Westphalia is a very big federal state of Germany. It's about 18 million, so it's a huge project. You go to the electronic file, and also when you see the E-Codex, it's quite well known on that, going on for many time. And you know, we work with many languages, and this is one of the small problems or big problems. So we move on to Sebastian Leitner. What's happening in Austria? Started a bit earlier, so some advantage, a smaller country, and only one federal judicial system, and also one provider. That's also maybe some advantage. Sebastian Leitner is from the Federal Computing Center. Sebastian, please.
Okay, thank you very much, Professor Schweighofer, for the introduction. I think, oh yes, now I can start my video, okay. So let me share my slides. There we go. Okay, thank you also, Isabel, for your very interesting presentation, especially your last part was a little bit already a start for my presentation. I must confess in the beginning that the title is a little bit of a misnomer, because the focus of my presentation will actually be on e-justice in Europe as a whole. So I will not really talk on the national activities actually in Austria, but more focus on what's going on in Europe in general. As you might know, in Europe, there are several actors active in this field besides the European Commission. From a more central perspective, you have a lot of initiatives going on from the member states, and Austria is one of the member states who is particularly active in this area. So I hope I can give you some insight on this and try to give you a quite broad overview without going too much into the details. So just an overview of the topics. I will, on the one hand, talk about E-Codex. Isabel has already introduced it a little bit. What are the general, more or less, administrative activities going on with the system, and then a little bit talking about the recent developments on the use cases. I will also talk shortly about the interconnection of registers, such as the interconnection of the land registers and business registers for allowing Europe-wide searches. Then shortly also, in the end, I will talk about some of the other topics. And one of the focuses will also be the new initiative on the digitalization of justice systems that is currently under negotiation within the European legislators. So first, talking about E-Codex, as Isabel already mentioned, this is a system for the electronic exchange of legal documents within the judiciary in cross-border cases. So it's specifically designed for this case. It's decentralized. It doesn't have any central component. It's for communication directly with between two member states. It's also based on interoperability standards to ensure that it can be integrated fairly easily with any national system. This has been developed over the course of the last decade, more or less, in a consortium of several member states and other organizations headed by North Rhine-Westphalia, but also with a very strong involvement of Austria, who especially were very active in the development of some of the technical software components. This development was under several EU-funded projects. So these are always lasted for 2 years or sometimes a little bit more. And the recent one of this was the E-Codex 2 project, so maintenance of E-Codex. The project focused on maintaining the software, improving it, providing some support to the users who implemented it in the various use cases. The problem with this project-based approach is it's not very sustainable because the project ended at some point, and this is actually the case for E-Codex 2. It ended in November of last year. And then you have a gap until the next project starts, where you can't really provide support or maintenance because there's no funding for it. So what was the question, how to solve this? It was decided to give it to an agency of the European Union. This is EU-LISA. So this is the European agency responsible for IT systems in the justice and home affairs sector. So far, it was largely busy in the home affairs sector with several systems for the asylum system and so on. But with E-Codex, it will also take over responsibility in the justice sector. For this transfer, it was necessary to create a union regulation, which has been introduced as an initiative from the European Commission December 2022 and has been negotiated over the course of last year. An agreement has already reached. The regulation is not yet published and enforced because there are still some last refinements, for example, on improving the language of the legal text. As you know, the European Union, it has 24 official languages. That's of course a task that takes a bit of a while, but it should not take too much longer. And then the handover to this agency can take place. And it is scheduled for July 2023. So that's still about nearly 1.5 years. And for that time to cover, it's still another project by member states is going to happen. And this is the E-Codex 3 project. It will hopefully start in a couple of months. It will continue on developing the system and will also, of course, ensure that this handover takes smoothly, that EU-LISA actually has all the knowledge and that this gets transferred to it. So let me switch to the use cases. Oh, sorry for the German word. I just saw that I didn't change it to English. Talking about the civil use cases, one of the ones that's already in place for quite a long time is the European payment order, where, for example, between Austria and Germany, quite regular exchanges happen, but not all member states are yet connected because so far the use of E-Codex is largely voluntary, depending on the initiative of the member states. However, this will change, for example, with the service of documents and the taking of evidence. These two use cases have been recently updated with 2 regulations that are now are soon in force. And for this, it will be mandatory to exchange these messages electronically, and for this the E-Codex system was chosen. Currently, the technical specifications for this are under development, and it will take, I think, 2 more years until this is actually in place. There are also some other use cases in the civil field under development. For example, the Layla project wants to develop a platform for judicial auctions on a European level. And another quite interesting case is the iSupport system. This is under the authority of the Hague Conference on International Private Law. It's actually one of the cases where E-Codex is not only used within the European Union, but also with countries outside of it, such as, for example, the United States or also Brazil. And this system is also continued to be developed further and also extended to more member states. It's used for recovery of child maintenance and child support in international cases. Another topic, maybe also another activity that's currently being planned for the European payment order process. So what Austria currently plans is starting a project with some other partners on developing a case management system, which can then be delivered to the member states. So this should be something making this international use case, making a case management system that is available to all the member states. In the criminal field, on the one hand, there's, of course, for example, the communication and financial penalties, but one of the main topics there is the European investigation order. So that is used for exchanging of evidence between criminal authorities. Here, there are a large number of activities going on besides the European Commission developing a backend system, the E-Codex platform, which will use E-Codex to transfer the messages. There are several projects for some individual member states, but also for groups of member states that want to that work on implementing the infrastructure and putting this in place. The current one, for example, is the EXEC2 project, which are a total of 13 member states, including Austria, who is also coordinating this project, and Germany. There we set up the infrastructure of E-Codex, and we also work on integrating it with the national case management and the national identity management systems. So this was the topic about E-Codex and a little bit of an overview there. Now there is some legislative activity going on of the Commission, because it has published a package on a digitalization of cross-border judicial cooperation in last December. And these are several regulations and also, I think, one directive under negotiation. I will talk a little bit about this piece, and that's the regulation on the digitalization of cross-border judicial cooperation. So as mentioned before, so far the electronic communication was largely based voluntary, except for taking of evidence in terms of documents which will become mandatory soon. It still depends on the member states to do this and to decide whether to do this, and most are still referring to older versions of communication such as paper or even email or fax. But this is supposed to be changed, because the one main provision of this regulation foresees a mandatory electronic communication between judicial authorities via a decentralized system, and this will most likely be E-Codex. And the regulation refers to all the legal acts of the European Union on judicial cooperation. For example, the European arrest warrant, the European investigation order, the European payment order, and so on. It will also foresee that there will be electronic communication between natural and legal persons and the judicial authorities. This will be optional for these private persons, but the authorities will need to accept this form of communication and will be ready for it. And what will also be developed is on the e-Justice portal of the European Union. This will create an access point. This kind of electronic communication is currently only foreseen for civil matters, but it might be possible that during the negotiations, this might also be extended to criminal matters. The regulation also foresees a legal basis for hearing via video conferences, both in civil and criminal matters. However, currently the provisions are not very clear. There are several open questions, actually, especially in the civil cases. It's the question of what cases it could actually be applied. And for the criminal matter, it's the question how this relates to the EU EIO directive, which already has provisions for video conferences. Then there are also some other topics, such as the requirement to accept electronic signatures and seals as defined in the E-Codex regulation, and also to accept electronic documents. This regulation will also require amendments to all these legal acts of cross-border judicial cooperation, which will make a reference that the electronic communication will become mandatory. Regarding the implementation, as it is still in a very early stage of the legislative procedure, so this will take still quite a while until it's actually in force. And from that point on, it will be a step-by-step process, starting with some instruments such as the European arrest warrant or the European payment order, and will then slowly be extended step by step to more and more instruments over a time frame of 8 years. Despite this more or less horizontal regulation, there are also some other regulations extending electronic communication in terrorism cases and also for joint investigation teams. But I will not outline this further. Then let me come to the next topic. Just briefly, the question of the interconnection of registers. So what's the issue here? All the various registers, such as the land registers, the business registers, and so on, are hosted by the member states. They are only for the territory of each of the member states of the European Union. And the goal is to actually allow a search for whole of Europe and also in all the various languages of the European Union. And for this, a central search shall be established at the e-Justice portal. One of the of the internet connections that's currently under development is the LRI, so the Land Register Interconnection. This is still under development. It's based again on voluntary cooperation about the member states. Currently, after 2 projects, the LRI 1 and LRI 2 projects, there are 3 member states, Austria, Estonia, and Latvia, who have established a technical connection to the system. However, the system itself is not yet live in production. There's still some obstacles that need to be solved, in particular the questions of authorization and payment. So the reason for this is the land register data is normally not available to everybody, but some documents might be restricted to certain privileged persons, like legal officials in the courts or legal professionals like notaries. Also, for example, a name search, so that you can actually look at what property a person owns in all of Europe. It will only be possible for those people. Currently, there's not really a solution how to do this, but the LRI2 project has prepared a proposal, and the European Commission is also working on solving this. And the other topic is, of course, how to make the payment for all these national registers that are connected. The IMULA 3 project is another project, which is also like the LRI2 project, finished quite recently, which, while the LRI2 project focuses on the technical aspect, the IMULA focuses more on the content. So it creates some kind of common semantic, the European Land Register document, which shall allow the understanding of the various land register data from all the member states. So some other registers that are interconnected are the BRIS. This is the Business Register Interconnection Service. This is actually already in place for several years. It's also already connected for all the member states. The reason here is the European has a competence, and it's actually mandatory for the member states to connect there. The IRI, the Insolvency Register Interconnection, is already in place for several years on a voluntary basis. It is now changing to become mandatory. There's a new version of the system since last year, and so far about half of the member states have already connected. The BORES is another register interconnection that's currently under development. This is the Beneficial Ownership Register, and it will go live probably at some time this year. One of the issues here is also that the topics of authorization and payment need to be solved here as well. Hopefully these topics can be solved for all the interconnections at the same time to get some kind of synergy. 2 more topics are the European Court database in civil matters and the criminal court database. So the European Court database contains data about the civil courts across Europe, providing information about the competence, the jurisdiction, and so on. And the criminal court database shall more or less be the same for the criminal courts and also the public prosecutor's office. For now, it's primarily used for the European investigation or the use case that's under development. And here also the member states have several projects, such as an ongoing CCTB project, to provide the data there automatically and ensure that it's up to date. Okay, I see that my time is already quite close, so I will speed up just this short slide. So I will not go into detail here now. There are several other topics, of course, going on a European level. The e-justice portal that I've already mentioned that contains all this interconnection of registers and other information is constantly being updated. It's also available in a new version. Video conferences is a big topic that's being discussed in several forums, of course, following the pandemic and what we're going on here. Austria is also planning to have start a project here, the Simplify project, where we want to remove some of the obstacles in cross-border video conferences to draft a new workflow, to provide some recommendations, because of course the technical thing is quite solved, as we can see right now in this moment, but it's still often from an organizational and legal point of view sometimes quite difficult to do this. Then for the European Public Prosecutor's Office, which which became active last year in June, they will probably also use E-Codex as a communication system internally between the decentralized delegated prosecutors in the various member states and their central authority. And of course, artificial intelligence is always a big topic as well. So here is just a short overview of the projects I've mentioned during this presentation and where Austria is active. And with that, I will finish my presentation. Sorry for taking a little bit too much time, and thank you very much for your attention.
Thank you very much, Sebastian. Just for clarification, European Union has only 27 jurisdictions when you consider it in the American sense. So we lost actually 3 with the United Kingdom, and European Commission is doing coordination work. So it's the member states have the full authority, and then some countries, like in Germany, it's then the federal countries is doing the work, and we're moving to digitalization. Austria is quite far advanced, so you have to do everything electronically. In Germany, it's still moving a bit under this. Then registers are online, electronic available, and the interconnection is developing very fast. And there's a lot of communication in particular forms, channels like in E-Codex. So, and there's a lot of video conferencing going on nowadays, and already huge practice about electronic court proceedings. So quite interesting. So, but I guess the client, and that are the attorneys, the solicitors, want to have more. And Stefan Eder is quite well placed because he knows many jurisdictions due to his huge experience in the legal environment. What do you have to say, Stefan? Are you happy with everything, or you like to have more?
At the beginning, I'd like to have a screen, please.
I can't share.
It's okay. Okay. Thank you very much, Erich. I'll first will share my screen and start my presentation. Actually, at the beginning, hopefully, not at the end.
It works fine. Looks good.
Oh, getting better. Okay. Yeah. Thank you very much for having me. And of course, there's always reason to complain. And so, if I answer to your question, I would have an endless list of wishes. But honestly, in Austria, we need to say that we have sort of e-justice support for more than 20 years. Just to give the audience a bit of a feeling, for more than 20 years, any laws and regulations, at least on a federal level and a regional level, are published electronically. There's no print. The data is made available on an interface, and the same actually with respect to judgments. We actually mandatorily, as lawyers, communicate with the courts electronically. That means we deliver our applications through an interface electronically, and we get back whatever is there in communication and decisions in particular from the courts electronically through an interface. So we have electronic communication for quite a while. The same, Sebastian already mentioned, sort of the European element of the various registers, but the same is for all our registers. So our land register, our company register, and whatever we have in that respect is electronic, and we again, our filings and sort of decision making in that respect is communicated electronically. So we are not experiencing, for example, the obstacles Germany had sort of the last 2 years on establishing communication between lawyers and courts. That is working for a long time, thanks to the federal center where Sebastian is working very, very well. But nevertheless, of course, things are ongoing, and we had an interesting exchange with also the support of the EDV-Gerichtstag, where Isabel is sort of also comparing Austria, Switzerland, and Germany in the various discussions on advancing further in e-justice. And actually also already that discussion brought about a lot of interesting topics, which I'm trying to address. So actually in my presentation, which I'll try to keep very short, I will try to look into two things. Number one, what are there in terms of systems for online dispute resolutions in Europe? And interestingly, this is more a European project than it's a local one in Austria. And the other one, sort of more on our Austrian level, what are our experiences in particular through COVID in terms of how might online proceedings work in exchange with a court, and then coming back to Eric's initial question, what have we to complain about, or what might we be looking for in terms of improvement? Now, our communication with courts, sort of also from the very beginning, is one sort of that is a happy experience. But if we go further into, go further into sort of this issue of online dispute resolution, we are seeing quite a, I would say, fragmented environment. We have a certain idea of how e-justice through courts might or should work. And we have various platforms which come out of EU regulations, but not a final system here on a local level. We see e-arbitration, which is sort of an out-of-court, more private arrangement, which at the end of the day is based on arbitration agreements. And we see e-mediation on private platforms, which you're all used to and which have in certain areas quite a big support because they are relatively informal and quick, but very often not leading to a binding final decision. My focus here is, of course, rather on the legal online dispute resolution. There we have two regulations, one from 2013 actually, which is a directive, so directly applicable with respect to the online dispute regulation for consumers. This is a platform actually established by the European Union for all the member states. So it was also directly enacted in this regulation, and each country sort of has the obligation to nominate contact points for such proceedings. So what's the purpose of that platform? The purpose of that platform is that consumers and business interact on dispute issues. It is established since, so the regulation, as I said, is from 2013. It is established since 2016, and it has sort of a form where you can upload your request, which is then sent to the other party in order to probably come to a pre-agreement without a sort of formal proceeding, or otherwise is processed through the platform. The other one, the other regulation, which is a regulation by the European Union, also from 2013, is dealing with alternative dispute resolutions for consumers, where the respective countries should have or have meanwhile implemented alternative dispute resolution systems for various areas. In Austria, we have some for example, with respect to energy and telecommunications and similar things. And this is also in force since 2015. So I have here a couple of those right for alternative dispute resolution platforms. You have that for passenger rights, energy control was one I mentioned. There's a so-called mediation center for the lending business, or the banking consumer loan business. There's one for internet issues and for telecommunications, as I mentioned as well. So these are two systems which are next to each other. The local one for alternative dispute resolution is rather one I would see as a mediation platform, and the online dispute resolution platform is one that is settling proceedings through this interface. The acceptance is the European Commission sees it as extremely good. They have sort of 3.3 million visitors on their platform, but actually only 17,500 actually then proceedings have been enacted through the platform. I think that was the numbers are from December 2021 for the year 2020. So in a way, there are systems. The acceptance is not that much. There is not any initiative to come to complaints with respect, in particular for P2P decisions, and it is not a format where you could say it is highly attractive to everybody, or it is not known to everybody, because otherwise we would see much more complaints through those proceedings. Here technically how it's managed, and that the dispute should be settled within 90 days, but actually as I said, the number of proceedings is not overwhelming yet. So hopefully those platforms will continue to evolve. And now let me quickly move over to the issue of sort of our local experience with court proceedings. Some of the elements Sebastian also mentioned already. To the COVID pandemic brought some developments. We had extraordinary legislation that allowed virtual hearings, provided the parties agree in certain areas. Also, those proceedings could be ordered by courts. We have it in particular in areas where we have so-called closed proceedings like insolvency. And those regulations were time limited, and we all hope that at least to some extent they will continue or will be made more permanent and probably after being adapted. Now, what are the issues we are facing in those proceedings? It is, as you can imagine, a principal discussion about what are rights of parties in such proceedings, and how can we move from a system that was developed for in-person, in-court, to use new technologies without any impediment to those rights. Now, what are those principal rights? One is open and public proceedings. So the public can view and participate and confirm themselves sort of by participating that this is a fair proceeding with equal rights to the parties. The parties have same right to participate. The parties sort of either in civil law are the parties who litigate, or in criminal law is the state prosecutor and the defendant on the other side. There's always a level playing field. It is sort of a direct interaction between the court in person with the parties in person, and or any witnesses, for example, or any experts. And it is for all the other participants in that proceeding to watch in that interaction, to see the mimics, to make sure that there is no influence on a witness, and things like that. And clearly that no party should be excluded. Also, that is, of course, a particular issue when we speak about potential digital means for proceedings. Now, what are the challenges? The challenge is, how can we meet those benchmarks, constitutional and others? And what are these sort of issues we need to overcome? The one is authenticity, so the personal interaction between the judge, the party, and the witness or the expert. Is a video line that is probably of poor quality, giving the same sort of impression of a person that is, let's say, sitting in front of the judge and sweating because of his lies, or sort of, are all parties having the same technical standards, and are they reliable? One party might have an excellent line and good technical equipment, and the other one might not. So the way to participate is not the same, and how can we overcome that? Or what happens if a party drops out of a proceeding, cannot participate? Is that a fair proceeding? And how can the public participate? Right? Is it a good way to say proceedings are streamed on a website? And if they are, is it then okay if everybody is copying, restreaming, probably amending the stream or interacting with the stream and manipulating? And how can we protect from that? So there's a lot of concerns of external influence and manipulation of unfair treatment by a party because of different technical starting conditions, and so on and so forth. Now, there's not an immediate solution to that, but I think that is the things we need to work on. We have our courts, our state legislator, our technical support people to work on. One thing sort of to say is it is not completely new that this technology is being used in proceedings. So we have, for example, one instance where we see quite often that a party or a witness may come to a distant court to participate in a proceeding where we have a line court to court and people are interacting on such a line. So that is a proceeding that is standard, that is well established and accepted and not causing a problem. So it shows, and this example shows, it's a sole example, but this example shows that there are ways, there are possibilities. One might be to have distance proceeding by going to the nearest court and using the technology there, provided that all courts have the same sort of technical infrastructure. What will we need to do in addition to the technical side? There will be need for adoption of criminal and civil procedural legislation to make clear what the rules would be, how we can protect parties, what are the rights if a party, for example, drops out or does not have a fair proceeding, is the proceeding to be stopped, repeated, or whatever. It's also the issue of how can we make such proceedings or protect such proceedings to protect their credibility. We need more definitions and support on technical standards to create a sort of open accessible system that also allows for public to participate in an appropriate way. And so we need, at the end of the day, that the Bundesrechenzentrum, Sebastian, to address you, offers probably also alternative technical options to get us forward in that context. And that would then sort of allow us also to have such proceedings probably cross-border to close the circle in Europe over the various borderlines. And with that, I'm closing and looking forward to your questions. Thank you very much.
Thank you very much. I also mentioned that Stefan is also quite active in cooperation with the scientific field. He's organizing a yearly conference, REMAP. So moving to discussion, I guess Roland, you take over.
Sure, yeah, happy to. I think a lot of questions were asked already in the chat and answered in the chat. I think, first of all, thank you for the wonderful overview of all the different things that are going on in e-justice on a European level. And for me, it's interesting. It sounded at the beginning like there's a lot of work that's being done in terms of just facilitating communication between lawyers and the courts, and then communication between law enforcement authorities in different countries. And that seems to be sort of like the first, one of the first tasks of like digitization of, court processes. And then, I appreciate also that concept, that use case of connecting the registries of corporate names, corporate registries and property registries. I think that's also interesting. That's one of the areas that the EU is trying to tackle. And then, of course, ODR. My next question would have been, well, what's the EU doing, or what are the different countries doing in terms of facilitating, helping actually individuals like, that are in a lawsuit resolve their disputes, and there seems to be some work going on ODR. And it's interesting for me that that seems to be sort of a EU mandated solution, ODR solution. And so I just want to thank you for the great overview. I know I personally, unfortunately, I have a hard stop at 2:30 today. I have another meeting I have to step into, but what I would like to do is just to leave the the session open so that, you know, folks who haven't had a chance to ask their questions yet, you get a chance to ask their question. And maybe Susan, maybe you can help sort of moderate. I'm very sorry. I unfortunately have a hard stop right now, and I have to
leave it open until 2:45 US.
Yeah, so let's just let it run a little bit longer. I just wanted to thank Erich, Isabella, and Stefan, and hold on, I forgot Dr. Mr. Leitner, also Sebastian. Thank you all for this great overview. I think it's been really interesting, and some interesting things to, you know, specifically in the comparison. You know, where are we in the U.S. in this sort of digitization? And many projects that were started and launched, some of them failed, some of them succeeded, and I think our group has like a lot of context here to also share. And so I always enjoy the comparative aspect the most, but again, I'm very sorry. I just have a hard stop today at 2:30. But let's keep the channels open, and, you know, maybe between Erich and Susan, you can perhaps sort of moderate the next couple of questions.
Sure.
But my apologies, I have to run, and I see you all hopefully at the next occasion.
Yeah, thank you for having us,
Okay.
Roland, and we stay on with discussion. Thanks.
Okay.
Bye-bye.
Thank you so much. Bye-bye. All the best. Thank you.
Eric, I'll let you take the floor if you're comfortable, and you can field some of the questions and discussion.
Yes, sure. I will do. Please, hands up. Who is the first?
You can also take a look in the chat. Sometimes they will drop, as you know, you've been pretty active in there.
Okay, just for the ODR, it's I followed the discussion in the United Nations Commission for Trade Law in Untitled, that's in Vienna, and it's a bit different. We have a strong position concerning some restrictions to arbitration. So when it comes to consumer disputes, that means high volume, low value. That's mostly restricted here in Europe. So there's a lot going on. It has to be properly guided and supervised. It's not as far going as in the United States. It's for legal reason, actually. So there's a lot going on, particularly when it comes to telephone bills. And it's not as decisive as it maybe should be. We work on that. Then what Roland mentions, it's a lot of registers. You know, we had many books, old books, going back to centuries, and they're now online. That's a huge development when it comes to land register that you may not have in the United States in all jurisdictions, business register, then also the registers of the courts, then a lot when it comes to payment orders, execution orders, all that is now quite easily to be done by electronic means. And also now the communication part. Yes, we used paper, we used fax machines. Now it's electronic, moving on to that. And you also may notice that in Europe, we have this electronic signature. And when it comes to the public sector, you can't say send an email, you have to say I am who I am, and you need some kind of proof, and that means you have to sign with an electronic signature or something similar. So that's a restriction, actually. It worked quite well within lawyers, and also the private sector is moving on, but still not everybody has an electronic signature. And we learned a lot in this kind of COVID-19 situation, online proceedings. And there's quite good practice, actually. In quite many cases, it works fine. Not in all when it comes to disputes, discussions before a judge, you have to be on site. And we have many questions are open. Also, Stefan Eder mentioned that when you see that you have witnesses and you can't post everything online, you have to find a way to see who can be here, who can listen, not the whole list of witnesses. They have to wait somewhere in the closed room, as they do now. You may do it a bit later, we'll see. Then you have also the kind of personal data, private data, how open is the judiciary? There's also discussion about that. So it's some our particularities we have here. So then de-anonymization, yeah, this nice project actually I've seen also in the chat. In our case, the most concern is now decisions. Yes, we don't publish names of parties in judicial decisions, with some exceptions if it's a legal person. And so not always published because we need to do some de-anonymization. And how far you can go, that's a bit discussion. And there are different practices actually, as some countries are more open, others not. But in Austria, we're quite strict, and in Germany also. So we don't find names. And also when the topic is clearly related to a particular situation, there may be also this may be changed too. So maybe some additional comments, particularly for the chat from Sebastian, from Isabel, from Stefan. Okay, maybe Sebastian, you can repeat this reply. It's interesting.
Yes, because I think somebody in the audience got asked if for reasons of social justice, basically there would be some shift to de-anonymization, so that but I think that's quite unlikely as the situation is in Europe and in Austria right now, because since the GDPR, data protection is more and more important and it's more emphasized. So I think currently it's quite important to actually anonymize any decision that are published. I mean, as far as I know, they are anonymized already for many, many decades, or probably, I don't know how long this is going on already. Currently, it's just the intention to reduce the effort on the court stuff, and also maybe to broaden the scope, because it's mainly the decisions of the Supreme Court that are published, and maybe it would be helpful to publish more decisions. But of course, that's only possible via support from AI tools. It's not something that could be done manually, because it's just too much effort.
Quite right. I may also remind we had these discussions with civil court countries and particularly also common law countries. And I remember Graham Greenleaf said, and that's still true, and also with Booker Jaffa from the Scottish jurisdiction, how we can understand a judgment if we don't know the names, the situation. There's still some truth of it. It's a question of the openness of the judicial system. And also when it comes to videos online forever, and it's clear you have names and you have also pictures there, videos. So we have to discuss that. And at the moment we are quite strict, that's true. So nobody knows that you were in court. Even maybe the public knows it, the newspapers, but normally it's not. So that's also a huge burden for the actually judiciary, for the courts, because they have to find resources to take out all the names and data that maybe lead to a particular person, and do that automatically is a very nice, difficult task. Many working on that actually. So Mark, you have some questions. I refer to you because you're good in this kind of, let's say, producing nice documents for the courts. And you're also familiar with Austria.
Hey, Eric. Yeah, I was just curious about how you're dealing with people who can't afford lawyers. Is that given much attention in these new e-justice initiatives?
I may answer that. Stefan, Ida also. We have, particularly Austria is not a good example. We have high fees. Germany may be lower. This is, we have this kind of ODR systems voluntarily that solve a lot, but if you are poor, you get support from the court, you get a solicitor. But if you're between the very poor and then you have a problem, that's the reports from the Council of Europe doing regular reports in the judicial system, and the fee problem is a big problem actually. So we have to work on that. We have now some, thanks for this question, Mark, quite interesting. And I hope we will see a bit more about this exchange of electronic documents, how it will go on. So we have a question. First, I've seen the hands up from Janakia. Sorry for the pronunciation.
That's perfectly fine, Professor. My question's on your comment in the chat about how case law is becoming more and more important, and you're moving closer to adoption of stare decisis, perhaps. When, why, and how did that start happening? If you could shed some light on that. And how do you think that'll affect any attempts at adoption of AI in your judicial system?
Okay, yes, you may know the famous remark of Napoleon Premiere. The judge is only the mouthpiece of the law, and that's it. But that's not true anymore. The laws are not as good. We have quite many rules. Also, European Union is doing a good job, doing too much, and then they are compromised, not really workable. And the judgment is the best tool to see how it works in practice. They have done some kind of a dispute, and it's solved by a judge, and then you see how the whole topic is made practical. And we have also quite old rules, like in Austria, Germany, civil law codes over in 100 years, 200 years. And here, the judges develop it further. There's not much difference anymore to the common law systems. Formally speaking, yes, it's a decision for one case, not for all. But in practice, the High Court decides, and the lower courts should follow the decision. Otherwise, it's a problem. It will not stand. So it's in practice, you have rules in common law systems. We have many more rules, yes, but still the court decides in the very end. The legal review process is getting stronger, also due to the administration is more and more controlled by courts, and therefore the case law is getting very important. You have to look at it, and therefore search procedures are important, and also artificial intelligence to see what is the best decision for this case. So a lot of practical work is done now in this regard. Okay, is it okay?
Thank you.
Then we have Isabel, please.
Yes, thank you. I wanted to answer the question Mark just asked from the German perspective, because it's really a problem we are currently seeing. Poor people have less access to justice than rich ones. They can't afford a lawyer, and of course they have the possibility to write to the court, and if their financial situation is not very good, they get the payment for a lawyer, but they have this very high obstacles. They have to be able to cross before they have access to court. And the idea is that some kind of online availability and some kinds of form for simple cases where everybody gets support is something that's very much in the current political decision and discussion. What can we do to make court more accessible, to lower the fears of the people, to use simple language to reach the people who otherwise would not have access to justice. And everybody who discusses in Germany agrees that in our times it cannot be possible, that people in Germany don't feel as if they could access justice because they are too poor or because there are some language problems or something like this. So very good question, and it's a challenge at the moment for us.
Thank you very much. That's addressing an important question actually, and all this kind of ODR is maybe a help, or advanced system of monetary orders maybe also help, because that's also quite developed, but it's at the moment it's very formal. Not much decision is in there, but there may be some development in that regard. As I mentioned, in Singapore, I've seen some, but there's much more to do also with some kind of evidence check of claims that may be helpful. So, are there further questions, remarks?
I would just like to come on at this point and thank all our speakers on behalf of Codex and Eric for leading a brilliant session. Thank you so much, especially since it's so late where you all are. So thank you, and thanks to our audience. And hopefully you guys will come back. We'll have another program in a couple of weeks, and then watch your inboxes for email about Future Law, our big conference, which is April 7th. So thanks, everybody. See you next time.
Well, thank you. And yes, the Codex conference is a great conference. Stefan Eder was there, and he speaks as highest regards. Okay, thank you, and
Thank
for
you.
having us.
Good night.
Good
Bye.
night.